Hear ye. Court of Appeals for the First District of Texas is now session.
Please be seated. Good afternoon. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 0123-00481CV. Brandy LISS, Independent Executor of the Estate of Mary Jane, Travis James, and Bay Area Shooters Center, LLC, versus Cushman and Wakefield of Texas, Inc., Edward NOWOKEDIM, sorry about that, Ting So Hang, and CYRIL CHIOSA. And starting with appellant counsel, will you please make your announcements?
Correct. Jill Schumacher on behalf of the appellant.
You did, but that's weird. Okay, so appellants on the side. And I'm sorry, Ms. Schumacher, you're representing all of the appellants today, right?
Correct.
Okay, thank you so much. Appellees?
Good afternoon, Your Honor. And just to be clear, the placards were here.
That's okay. That's okay.
My name is MUKUL KELKAR, here arguing on behalf of the appellees. I'm joined by my partner, Glenn Ballard, and Dwayne Day represents the individuals.
Okay, thank you very much. And appellant, you are going to take 20 minutes. How much did that you want to reserve for rebuttal?
5, please.
Okay.
And to help the court is WOKEDIM.
Thank you. Say that for me again.
WOKEDIM.
WOKEDIM.
Ignore the end.
That would have helped me tons.
Okay.
Thank you for that.
Thank you.
Okay, so each side then will have 20 minutes and we'll reserve 5 minutes for rebuttal. We have here the timers. I'm sure you're all familiar. When the light turns yellow, that means you have 1 minute. And then of course red means stop, but if you're in the middle of answering the question, please proceed. We have read all of the briefs very carefully and we are very familiar with the facts of the case. It would really help us if you can get straight into the arguments. There is one thing that I would like both parties to address that would really help the panels because it's going to really help us with the issues that we're considering, and that is there's 2 orders that the trial court entered on motions for summary judgment, and we need to get some clarity as to what the parties believe the trial court ruled on. And with that, we're ready to hear from the appellant.
Good afternoon, and may it please the court. While we have served up a lot of drama and war stories in our briefing, this appeal is technical. The rules of civil procedure limit a summary judgment to the grounds expressly raised in the motion. There are only 2 grounds upon which this court needs to rule: capacity and statute of limitations. The challenge in this case is applying multiple civil appellate doctrines to a record with a heavy motion practice, multiple vague orders, and a lot of briefing. There are 3 categories of arguments in our appellate briefing: arguments that this court must address in order to address the summary judgment, arguments that this court has discretion to address, and arguments that would be improper to consider. I'll begin with the summary judgment orders because that's the best way to determine what grounds are before this court. An appellate court must rule on grounds that the trial court ruled on in an order. There are 3 orders in the record that relate to summary judgment. The first was entered on October 26, 2021, the second on November 3rd, 2021, and the third on August 23rd, 2022. On October 26th, the trial court heard 2 summary judgment motions. The motion that was filed on August 5th by NOWOKEDIM, I'm going to say that wrong because I practiced it wrong, I'm sorry, and the motion filed on August 12th by Cushman and Wakefield. The court issued an order on November 3rd clarifying what summary judgments were before it on October 26th. We know that for a couple of reasons. First, the November 3rd order begins by stating, "This is what I heard on October 26th," and listing the motions explicitly. Also, when you look at the 5th volume of the reporter's record, which is the record of the oral hearing on summary judgment, the court says, these are the two summary judgments before me. I anticipate making a ruling on them today. We see the ruling on October 26th. It is vague. It just says that the court granted summary judgment, but then the November 3rd order clarifies. These are the orders
Why is
that
that
were
a clarifying order, though? It doesn't say that it's clarifying anything. The October 26th order very clearly states that it's granting the motion for summary judgment by CNW. It doesn't specifically state the date. And then November 3rd, we have a completely separate order that does not say that it's clarifying anything. It very expressly states that it's granting the August 5th and the August 12th motions. So in essence, what we have is two orders, and we can't say that the two orders were all in the same motion. So help us wade through that, because I understand the argument, but it's hard for us to get there where the judge is not clarifying that that's a clarifying order. And it maybe help me if I understand whether the prior motions before August 5th were actually set for hearing.
Yes, they were set, it was a year prior. They were set in on November 2nd, 2020. It's at Clerk's Record 94. There's an initial...
I'm sorry, Clerk's Record.
So at first, look at Clerk's Record 59. They were initially set to be heard Monday, October 19th, 2020, and then there was an amended notice of submission November 2nd, 2020 at 8 a.m. So almost a year went by before the court's October 26th, 2021 order, and I think what's most helpful is look at the hearing on the summary judgment record, the court reporter's record in the 5th volume, and the judge says orally at the hearing on October 26th, 2021, this is what's before me, it's the two August 2021 motions, and I'm going to rule on them today. And then the order that same day, October 26th, 2021, says I'm granting the summary judgment motion. Then we have the November 3rd order.
If we agree with you that these orders, both of them were ruling only on the August 5th and August 12th motions for summary judgment, what are the implications? What remains?
So the grounds, so those two motions, and then CHIOSA, of course, in June of 2022, filed a motion that didn't have any substantively different grounds from the Cushman and Wakefield motion. The court granted the same motion as to CHIOSA on August 2023, just to complete the loop there. The motion, so there are two grounds. In all three of those motions, there are only two grounds: capacity and statute of limitations. And the capacity argument is raised in NOWOKEDIM's motion, and then Cushman and Wakefield raises capacity and statute of limitations. So the grounds overlap, and that's all in those two motions. The prior year, in October of 2020, Cushman and Wakefield asserted two additional vicarious liability and economic loss. Appellants responded and sought a continuance to get additional discovery. Discovery continued for a year, and then Cushman and Wakefield chose not to re-urge those grounds.
So you would say that those issues are not before us, that we cannot dispose on the appellate issues before us on the economic loss doctrine. And
so technically, there's kind of an appellate nerd doctrine out there that this court has discretion to rule on preserved grounds that were not ruled on by the trial court if it furthers judicial economy.
right.
We would submit this would not be a good case to exercise that discretion for two reasons. The first reason is that the grounds themselves are legally insufficient grounds to dispose of any claim. And so the res judicata impact in all candor for appellees would be unfair. But additionally, it would be unfair to appellants because we didn't have an opportunity following that year of discovery to respond to those grounds with the discovery that we said we needed in order to address respondeat superior and economic loss. But we have challenged them out of an abundance of caution to make sure that there was no waiver, and this court does have the discretion to address those grounds. There's a case out of the 14th Court of Appeals, I don't have the site, it's Korthauer with a K, Korthauer, that discusses that doctrine that would give the court discretion. If there are no further questions on what's before the court, I'll move on to the two summary judgment grounds that we believe the court must rule on today. So we discussed the grounds and the orders that are before the court. There are two other important appellate doctrines that limit this court's review. A summary judgment must expressly stand or fall on the grounds contained in the motion. This is the McConnell versus Southside Independent School District case. It's been the rule in Texas for the greater part of a century. That means that the grounds related to the issues are limited to the very short motions that were filed in the trial court. There's one exception. A non-movement for summary judgment has no obligation to respond in the trial court to a motion that is insufficient as a matter of law. The best case on that doctrine is the City of Houston versus Clear Creek Basin Authority. This is the seminal case. It's 589 Southwest 2nd, 671. It's from the Texas Supreme Court.
Why would the motions for summary judgment be insufficient in your view as to capacity and statute of limitations? Because those issues were pretty fleshed out. The parties were able to respond to it, and I think the court understood what the issues was that she was ruling on.
I think that's right. There are some additional arguments that are made. I mean, I think the court, yes, I think that those grounds, as stated, are sufficient, but we need to limit them to the ground that was asserted. So with the statute of limitations ground, for example, there are 4 claims that are expressly listed in that motion. They are the breach of fiduciary duty claim, the 2 negligence claims, and the civil conspiracy claim. On appeal, for example, appellees say that the DTPA claim was also somehow part of that summary judgment motion, even though they chose not to expressly list it. So as to the DTPA claim, for example, because it wasn't a ground for the summary judgment, that ground is insufficient.
And I don't disagree with that's the question I have, because I don't see the DTPA being asserted. But you would agree that the others were. That would be breach of fiduciary duty, negligent misrepresentation, negligent hiring and supervision, and civil conspiracy, at least as to the statute of limitations.
We have an argument that the ground is insufficient because it doesn't state the accrual date, but if the court doesn't buy that ground, then it is pretty clean as to the 4. And you know, the parties have acknowledged, and so this can be pretty simple for the court, I think. The parties have acknowledged that breach of fiduciary duty has a 4-year statute of limitations, civil conspiracy, and so that one obviously should be reversed. Civil conspiracy.
If Bay Area had the capacity to sue.
Yes, correct. Correct. Well, but there's 2 sets of, there are 2 sets of plaintiffs though. Bay Area, and there are also the individual plaintiffs.
Well, talk to us about Bay Area. Why did they have the capacity to sue?
Bay Area had capacity to sue under section 11.356 of the Texas Business and Organizations Code. Beginning in 1993, there's a footnote on this in the Levitt case that we cited, the legislature incorporated into its definition of a dissolved corporation under the Texas Business and Organizations Code an entity that was forfeited under the tax code as well. That definition continues in section 11.001, in which the legislature has made clear that a terminated entity under the Business and Organizations Code expressly includes an entity terminated under the tax code. The best case exactly on this point is the one that we cited at Clerk's Record, page 433. It's from this court's sister court. It's the Anna Malou versus Ira Hayda case. It's number 14-19-00018. It's a 1-issue appeal. The trial court concluded that the survival statute did not apply to an entity that was forfeited under the tax code, and the 14th Court of Appeals reversed because that survival statute does encompass the tax code.
How would you distinguish the cases from our court, including Green Acquisitions versus Everlasting Green, where we have concluded that if you forfeit your charter under the tax code, you must revive that charter in order to sustain or prosecute your claims?
So the holding in The holding, what you held in the Green opinion was that the entity had capacity to sue because it did revive its charter.
Correct.
But because that was the case, there was no need to assert the Texas Business and Organizations Code survival statute.
But it also would have been redundant for us to say that, wouldn't have been, if you have that survival ability under the business code, that you don't need to revive your ability to be able to pursue claims.
The opinion didn't address the business code. There were two ways, there are multiple ways in which an entity has capacity to sue. It could be that you revive yourself under the tax code, or it could be that if you don't, it's only when you don't really that the limited right to survival under the Texas Business and Organizations Code would exist. And when you look at all of the cases that they cited, there's a reason that they don't have a case that involves both statutes.
Right.
We have cited two cases that involve both statutes. The reason is they have one case that predates Section 11.356 that they cite in support. They have cases where it was a 6-year period and the business and organization statute is only a 3-year survival period. They have cases where there was no need to address it because the court found there was a waiver due to a failure to challenge capacity for a verified denial, and cases where we were revived under the tax code and there was no need to get into the survival statute. The only cases that I've been able to find that address both statutes hold clearly that the Texas Business and Organizations Code does contain this limited right of survival. The legislature made this express by including in its definition an entity forfeited under the tax code. They later, revised the statute. It was not a substantive revision, but it was just to make sure that the mistake being alleged by Appellees isn't made. I want to quickly on the individual claims. So we discussed, are there more questions on capacity? Okay. The individual plaintiff's claims, there is a half sentence under a contractual standing ground in which they assert that the individual plaintiff's claims
You
should
can
be
keep going. I know the time is coming up, but we do want to hear from you on that. So.
Okay, great. So there's a ground in which Appellees argue because there's no standing to sue for breach of contract, the plaintiffs have no claims whatsoever. So they sought dismissal of all of appellant's claims based on a standing argument. But appellants brought both contractual and non-contractual claims, and there is nothing in that ground that is sufficient to dismiss the non-contractual claims. There isn't even an argument other than a comma and a sentence. Notably, they have framed the contractual privity issue as a standing issue, which is incorrect. They point out that we didn't address this in our response, but because it's standing, it's jurisdictional. And the arguments that, and you're allowed to bring a jurisdictional argument in a summary judgment, but we also, because the court has an obligation to determine jurisdiction properly, the court gets to consider arguments made for the first time on appeal.
But I think the argument is far more than just lack of privity, right? The argument is that the LLC, the entity, was the aggrieved entity, and that the individual parties cannot bring those claims because they didn't suffer that injury. It was the entity that was the contracting entity that suffered those related injuries that formed the basis of the claims.
My read on the claim is that they're pretty clear that they're making it a standing claim. They say it throughout the paragraph on the claim. But even if that's not the case, the claim is limited to contractual grounds. It discusses contractual grounds for a paragraph, and then there's a half sentence that says should be dismissed, because there's no contract, the claim should be dismissed, comma, together with the rest of the claim.
Are there other non-contractual claims aside from negligent hiring and supervision, civil conspiracy, and the DTPA claims?
Yes, other than the breach of contract claim, the claims that we have, our pleading asserts that there was a fiduciary duty. We haven't discussed that in depth in our briefing because it wasn't addressed in the summary judgment, but we became a minority owner of an LLC. There were all kinds of fiduciary duties there related to, and this deal was more than just relating to the listing agreement. In addition to the breach of the listing agreement and the conduct that went along with that, there was deception and lies about an $800,000 loan that was converted. There was a lot of additional conduct that we claimed was, misleading under the DTPA, fraudulent, and breach of fiduciary duty. I see my time is expired.
Can I ask, because I still want to cover the DTPA stuff. I want to hear the best argument for why the individual plaintiff's DTPA claim is not exempted on the large transaction cap.
I think the cleanest way for this court to look at the large transaction cap argument is found in the 8th Reporter's Record, volume 82. And it's at the questioning of the trial, and Mr. Daniels asks Mr. Ballard of Appellee's counsel, he says, well, do you agree that the cases that we've cited could be read as suggesting that the consideration is all that we look at under the cap? And Mr. Ballard responds, and he says, they could mean what you're saying, they could mean what we're saying, but ours is the stronger argument. The cross appeal is an argument that our claim was frivolous, meaning that we had no basis in law to bring the claim. Even if we're wrong under the large transaction cap, as long as we have a legally cognizable argument, our claim is not frivolous, it's not brought in bad faith. We're allowed to bring it and to make that attempt. The trial court heard all of this at a trial. No findings of fact or conclusions of law were requested after the trial by appellees. That means the standard of review that this court is looking at is exceedingly high. When there are no findings of fact or conclusions of law, this court must imply any possible finding or conclusion on which there is legally sufficient evidence upon which the trial court could have exercised its discretion. I haven't been able to think of a higher standard of appellate review here for the trial court's determination on that claim. And the trial court certainly could have listened to that testimony from Mr. Ballard, the cases cited by appellees, and the plain language of the statute that says that we're just talking about the consideration for the transaction, and made the conclusion that it was not frivolous. Thank you.
Any other questions? Thank you for your argument. We're ready for appellees. We'll give you extra time. Do we know how much extra time to add to the clock?
I did not look at it recently, but I believe it was at least 5 minutes.
Okay, 5 minutes. Okay, you'll have 25 minutes for your argument.
Okay. Well, that will allow me to speak slowly then. Members of the panel, and may it please the court. My name is MUKUL, KELKAR, and I'm here on behalf of the appellees, respectfully requesting that this court affirm the trial court's dismissal of plaintiff's claims. Now, my prepared speech notwithstanding, let me address the question that Your Honor first asked about what is actually being reviewed at summary judgment. And the reality is the best evidence that we have that the entire record and all the summary judgments are under consideration are the fact that the appellants, in their own opening appellate brief, sought review of every single claim that that CUSHMAN WAKEFIELD and the other appellees made down at the trial court. Right? It is the appellant's own actions that show that respondeat superior is at issue. Vicarious liability is also at issue, in addition to the capacity and limitations arguments that have occupied the bulk of my opposing counsel's time here today.
But help us with the language in the orders, though, because it is less than clear.
Sure.
I understand that several motions for summary judgment were filed, but the reality is that on October 26th, the court was very explicit what specific motion she was considering on that day. In the order that she signed that day, doesn't tell us what motion for summary judgment she granted, but on November 3rd, she's very clear that she's granting only the August 5th and the August 12th motions for summary judgment. So how are we to construe these two orders together to conclude that there was a ruling on all of these motions for summary judgment, which I count were almost 5?
Right. So I would say basic pleading standards, Your Honor. What it is defined as much by what it says in that November order as by what it does not say. It does not call it a first amended order. It does not call it a corrected order of the October order. It does not call it a supplemental or supplanted order. right? They could have used this language. Now, the court does talk about what is under review at the time in October, but the order that was issued is broader than that, and
Wait, you're talking about the November 3rd order? Because
I-
that one is very explicit that it's only the August 5th and August 12th motions that she's granting. You're talking about the October 26th order?
Yes, Your Honor. So that October 26th order is broad or vague, or what descriptor you would prefer, but the point is that by not, in the November order, not saying, hey, look, the one from last week, please disregard, please remove it from the record, or strike it from the record, none of that happens. And that's not an accident, and it's not the job of this court, or any of us, to interpret the intent of the trial court in that moment.
But if the prior order had already granted all the summary judgment motions, what's the point of the November order?
Yeah, so it provides further, it could provide further clarity, it could provide a specific ruling as to that specific motion. It puts a finer point on the October litigation and on the motions for summary judgment that were argued in October. But the point is that there are two orders. There was no, and by the way, that all of this happened in the fall of 2021. This case wasn't disposed of until May of 2023. The appellants could have asked for clarification about this at any point, and no such clarification was done. And they immediately then, on appeal, appealed all grounds. We can't now go back and unwind those decisions and those actions and inactions by the appellants.
Well, let me ask you the same question that I asked the appellant. If we disagree with you and the trial court's ruling only pertained to August 5th and August 12th motions, what are the implications? What remains?
Right, so what remains is what was under review or the subject of the November 21 order was the August 12th motion for summary judgment, right? And so that motion for summary judgment speaks to Bay Area Shooter Center LLC's lack of capacity to bring a claim, as well as the individual's inability to bring a claim, as well as statute of limitations. Okay? And with respect to that, and as it gets to the core of my argument, the capacity claim, so there are three plaintiffs in this case, Bay Area Shooter Center, and then Travis James and his sister BRANDY, LISS, who stepped in as independent executor. Okay? Bay Area, as the corporate entity, is barred from bringing claims because its corporate privileges were forfeited under Texas Tax Code 171.251 and 252, and it also had its charter forfeited under Texas Tax Code 171.309. Okay? That is a distinction with a difference here, Your Honors. Those are two different concepts. Forfeiture of privileges and forfeiture of charter are two different concepts. And if you're not convinced by my briefing or by my oral argument, the best authority for that is this own court's opinion in the LT Mexican Restaurants versus Bacon matter. That was 921 Southwest 2nd, 247, I believe. And in that case, Your Honor, LT, this court held, 921 Southwest 2nd, 247, excuse me. This court, the first court of appeals, held that there's the 4 stages of corporate decay. There are 4 stages of corporate decay, all right? Stage 1 is you're a fully functioning entity. Think of every coffee shop, gas station you drove by, everybody wants to be a stage 1 corporate entity. You're a fully functioning operation. Stage 2 is when you fail to pay your franchise taxes. And when you do that, the effective failure to pay your taxes is your denial of corporate privileges. And your corporate privilege specifically is your right to sue or defend yourself in state court. Okay? After 120 days, under 171.309, your charter gets forfeited. So you go from being a forfeited, an entity with a live charter who just cannot sue or defend, to a forfeited charter, to a company with a forfeited charter. The best way to explain it is, think of an attorney who fails to pay his bar dues. He's not allowed to practice law, but he's not disbarred yet, right? So there's a stair-step approach. And then the 4th stage is voluntary dissolution. That's when an entity writes to the Secretary of State and says, hey, we're winding up, we're not an operational company. So the key here, though, is the appellants try to link stage 2 and stage 3 into one overall concept, and then accordingly apply this 11.356 survival provision. But that is a mistake. And the appellants, you heard it right now, they say we don't cite any cases about the interplay between 171.252 and the survival statute. And my answer to that is, you're right, we don't do that. And the reason is because 171.252 speaks to corporate privileges, which is the right to sue or defend yourself. It is a freestanding, separate, distinct concept. And as the LT case, as this court says, LT described it as the successive forfeitures of corporate privileges are distinct acts. And that's on page 253 of the LT decision. These distinct situations that Bay Area find it, just because Bay Area has allowed itself to move into a further state of decay, does not reward them with the ability to now sue and defend themselves when they didn't before. I mean, put it this way. Imagine if Bay Area Shooting Center doesn't pay its franchise taxes and it is suspended under 171.252. And for 115 days, they're not allowed to sue or defend themselves. Under the appellant's reasoning, what could happen is Bay Area could say, well, you know what we're going to do is, I know it's day 115 of us not paying our franchise taxes. Let's wait another 15 days. Let's wait for our charter to be forfeited also. Then we'll be able to take advantage of the survival provision.
How do those nuances work with respect to the recent amendment under the business code? Because
Yes.
I want to know if what you're saying is true, then how does that impact, or how does that interplay now with the amendment under the business code that allows for revival of the ability to sue both under the tax code and the business code?
Right. So, and as a preliminary matter, this case is subject to the prior tax code.
Right, I understand.
Okay, all right. So, under the new tax code, Your Honor, it still would not save them in this regard. And that is that you still have an independent duty to pay your franchise taxes. That is not a get-out-of-jail-free card. Even if your charter, even if you have this right to, this survival right, there is still an independent duty to always pay your franchise taxes.
But the survival statute doesn't say that. It doesn't say you have to redeem or repay your taxes to be able to sue. It says your right to sue survives for 3 years. It doesn't have all these other prerequisites or conditions to it.
That's correct. The survival statute, the new version does specifically include or the tax code, right? It does say that. And it does provide that, but it would still create that absurd result. First of all, LT describes it as separate distinct acts, right? It says that these are separate stages of corporate forfeiture. The comptroller forfeits the corporate privileges under 171.252,
Right.
and the Secretary of State forfeits the charter under 309. And so while it does now say a terminated entity under this chapter, what it still speaks to is the fact that you do not get the rights under 356 just because you've allowed yourself to move into further decay by failing to pay your franchise
So
taxes.
you would say under those circumstances, survival would not be allowed. You would never be able to survive the 3-year mark to be able to pursue an action.
You could, but you got to pay your taxes.
Right.
All right, you have to pay your taxes no matter what. And the reason we know that, Your Honor, is that the tax code provides a wide array of reasons as to why your charter can be forfeited. Right? So it's not just this timeline of you didn't pay your taxes and so now your charter is forfeited 120 days later. There's other reasons why your charter can be forfeited under the tax code. If you refuse to let the comptroller access your books and records upon request, that can be a ground for forfeiture. If you don't let the Secretary of State access your records, that is a ground for forfeiture. Okay? So there are other reasons, but the separate distinct act, as LT, not me, LT says a separate distinct act, that separate duty is unimpeached. And the reason we know that is from all of the cases that Your Honor just talked about. This Court of Appeals, in Green, in LT, in Transamerica, all cases that we cited in our brief coming out of this court only did a 171.252 analysis. And the reason is because it is its own silo, it is in isolation.
So we agree with you that there is no capacity for Bay Area to sue. Walk us through the individual claims and why were those properly disposed?
Okay.
And where specifically did the appellees ever move for dismissal of the DTPA claim? Because I don't see anywhere in the motions for summary judgment where that was challenged.
Okay, so to answer the first question about the DTPA dismissal, we do talk about in the limitations section, we do talk about all the 2-year tort claims. It is not artfully pleaded. I will admit that. As the writer of that brief, I'm happy to say that. But we do talk about the 2-year tort claims are subject to dismissal. Okay? That is on Clerk's Record 354.
How did you, I mean, so it's a statute of limitations issue, but now it goes back to the appellant's argument on insufficiency, right? What specific facts, because then you would have to determine accrual dates for those specific DTPA claims. Was that addressed anywhere? Was there any evidence presented on that issue?
Okay, yes, so so going back to the factual timeline, this, the real estate transaction closed in July of 2018. The alleged misrepresentations made by NOWOKEDIM would have happened in 2016. The claims brought by Bay Area Shooter Center didn't come until October of 2020, so 2 years and a couple of months after the latest possible date. The appellants, the plaintiffs in the trial court, never pleaded the discovery rule, never pleaded fraudulent concealment. They never gave any sort of equitable tolling for the claim. And as a consequence, the best evidence that we have, or the evidence that we argued that went unchallenged, is that mid-July 2018 was the date of closing of the real estate transaction. It was the end, by their own admission, the end of Cushman Wakefield's relationship with these individuals, and as a consequence, there is no further time. The accrual date has to be in the most generous form, in the most generous reading. That accrual date is July of 2018.
What about the representation concerning the K1? Because there is an allegation that they didn't discover any malfeasance or misrepresentation with respect to the K1 until, I think it was in May of 2019, if I remember correctly.
Right. So as a threshold matter, Your Honor, the appellants did not, in the trial court, address anything about the individual claims. That is waived. That horse was out of the barn back when they failed to file any response or make any response as to the fact that the supposed individual claims belong to the corporation, as we argued. Okay, and while I am arguing for all the appellees, this is the moment where there's a little bit of daylight between Cushman and Wakefield and the rest of the individual appellees, and that is that when you read an appellant's argument about this $800,000 and the K1, that all speaks to this other entity called CEL Arms Room Partners LLC, which is not even a party to this litigation, and their relationship surrounding the fallout of Travis James's employment agreement with the CEL Arms Room Partners LLC, which has never been brought into this suit. But we talked about the individual claims here, and Your Honor is right. I mean, there is no reference in the response, in the summary judgment response. And I looked at it carefully again this morning, last night. There is absolutely no response as to our argument that the claims all belong to the company. And if you don't make a response, you didn't file a response at that time, you cannot bring that up on appeal for the first time. And my opposing counsel does an admirable job trying to say, well, it's a...
Well, they can attack the legal sufficiency of the court's finding, even though they didn't make that argument in the trial court. And so that would be the legal argument, right, the sufficiency challenge in here.
Right.
That the trial court did not have a basis to grant the motion for summary judgment, notwithstanding their failure to respond. So how do you address that?
Right, so for the very simple reason that these injuries are corporate injuries. It speaks to it was a real estate deal gone bad. The counterparty for Cushman Wakefield was Bay Area Shooter Center. Bay Area was the one that suffered the injury as a consequence. And so the only potential, I mean, as Your Honor pointed out, the only potential individual injury that still could possibly be considered that they brought up is this fallout with CEL Arms Room Partners LLC, which is not a party to this case. I mean, down at the trial court, I'd say objection relevance. It has nothing to do with what we're talking about here. Okay? And for those reasons, we would say that the individual claims do not survive either. And if we go back to the Business Organizations Code, as Your Honor explained, the second reason why the corporate grounds do not exist is that the amendment, the plaintiffs or the appellants describe it as a clarification of the rule. They say that effective September 1, 2023, the Business Organizations Code clarified this survival right. So the old Business Organizations Code that was in effect and that controls this dispute says that notwithstanding termination of an entity under this chapter, i.e. Chapter 11 of TBOC, notwithstanding termination of an entity under this chapter, you have a 3-year survival right. Effective September 1, 2023, long after this case was disposed of down at the trial court, they now say, notwithstanding termination of an entity under this chapter or the tax code. Okay? They add this language or the tax code. That's not clarifying. That is not clarifying. That is expanding the scope of what it means to have a survival right. And once again, even that does not get them there when they have this separate independent duty to pay their franchise taxes, which they haven't done. So what we have here is a clear reason, the twofold reason why why the corporation doesn't have standing to bring the claims, because they haven't paid their franchise taxes under 252, and they also haven't, they don't get the privilege of the survival right under 11.356. The individual claims fail because they did not argue it at the trial court level, and there's more than enough legal sufficiency here to say that the injuries are all corporate injuries. Elon Musk can't sue in lieu of Tesla, Tim Cook can't sue in lieu of Apple, and Travis James and Brandy can't sue in lieu of Bay Area Shooter Center.
If this court disagrees with your analysis that all of the summary judgment motions are in play, would you agree that the appellees did not move for summary judgment on the James's individual claims for hiring and supervision, civil conspiracy, and violations under the DTPA in the latest summary judgment motion?
No, I would say that we argue that all of the injuries belong to the corporation, and the legal sufficiency of it. All the injuries that allegedly spell out. So, for instance, this sort of any type of negligence, for instance, that would be the negligence as to the interaction between Cushman Wakefield and Bay Area Shooter Center, which has been barred. But this idea, if what Your Honor is talking about is negligence concerning, or negligent hiring, or a misrepresentation concerning the $800,000 in the K-1, I would go back to my prior argument that deals with the transaction between those individuals and CEL Arms Room Partners, not a party to the case, or at worst, it deals with
Why wouldn't that be a claim between NOWOKEDIM and CHIOSA, though? They're the ones that allegedly made the representations and persuaded Mr. Travis to make the $800,000 investment. So the way I see it is they've alleged specific misrepresentations that were made by named defendants to a named plaintiff.
Sure. And if Your Honor, and if this court takes that opinion, takes that approach, I would just say once again, with all respect to Mr. Day, that is where there's a little bit of a difference between Cushman Wakefield in this case, who was my client at the trial court, and the other appellees. I mean, that clearly is it deals with a relationship outside the scope of any brokerage agreement or with Cushman and Wakefield.
Can we talk about the DTPA exemption?
Sure. Yes, please.
Can you explain to me how the $7 million alleged damages equals total consideration contemplated by the statute?
Right. So, I was surprised to hear my opposing counsel say that the best evidence is my partner's speculation at the trial court about what these cases mean and whether the large transaction, if that would, exempt them under the $500,000 claim. Look, what our cases cite to is that you can look at a series of transactions in order to determine what the amount in controversy is. As the plaintiffs have alleged, this is a multi-million-dollar damage model that they explain throughout all 6 of their petitions. That is the amount in controversy here.
But the statute doesn't say amount in controversy. It says total consideration of the consumer, by the consumer party.
Sure. Sure. So the consideration at that, so again, you can look at the series of transactions and the amount of money that was handed over or lost as a consequence, right? And so in this case, it was in the millions of dollars on a corporate transaction of a very large gun store that was sold. That type of consideration is, you look to the $7 million transaction. Yeah, the brokerage claim. I mean, let me put it this way. They're certainly not asking only $500,000 in damages as to Cushman & Wakefield by any means, right?
But there's a difference there. There's a difference. I don't disagree that their claim for damages far surpasses the $500,000. Right. But the statute is very specific. It talks about one transaction, multiple transactions, but it's all filtered or constrained to what the consideration paid. Doesn't say paid, but the consideration by the consumer. And so the focus is, of course, is that, you know, the DTPA, these exemptions are meant to protect unsophisticated consumers who don't have that level of sophistication, maybe in high dollar transactions. So we have to focus on the consumer here. The consumer was only going to pay a commission under the listing agreement. We can't really focus on the valuation of these larger transactions, because then to me, it seems like the purpose of that exemption would be eroded if we're going to start debating what the value of a particular commercial transaction is at any given point. The case that was cited, East Hill Marine, was very specific that they were focusing on the amount that that particular consumer was going to be paying for the boats that they would later use and sell for lost profits. But it was not focused on the lost profits, it was focused on how much the consumer had paid for the transaction there. So why wouldn't we follow that same reasoning here and focus on what Mr. Travis or the plaintiffs here were going to have to pay ultimately under the listing agreement?
Right, and for that, I would once again say that the appellants can't have it both ways, okay? They are also saying that we're responsible, that all the appellees are responsible for Travis giving up $800,000, which was actually paying money as part of the transaction, the $800,000, actually paying $500,000 in consideration as a brokerage fee. You can't, if you isolate it to that small, I mean, if we're just talking about money handed over, or the amount of consideration, if we define amount of consideration as the amount of money handed over at that point, by their own argument today, we know that that is well in excess of the $500,000.
One more question on that. Even if we agree with you, I can see a world we can say you're right, under these circumstances the exemption would apply, but nonetheless, given the fact that we're having a debate as to how even the statute is construed, how can we conclude that they bought this claim, that it was a groundless claim, if there is this confusion as to how we're supposed to interpret this particular provision? Sure.
So if Your Honor feels like there is a genuine good faith dispute about what the amount of controversy is, then that would not help us establish that it was brought groundlessly or in bad faith, but in full transparency. But what I would say, especially to the two former prosecutors on this panel, is that I would encourage you to read that cross appeal. I know you have already, but a read of the cross appeal. That is the stuff of professional responsibility nightmares. That is the definition of groundless and bad faith litigation misconduct. And to just brush it off as just a discovery dispute totally undermines the series of escalating transactions and disasters that were occurring at the trial court on this utterly baseless insistence that fraud was being perpetrated by the appellees in this case.
You timed it perfectly, 25 minutes. Thank you for your argument.
Thank you, Your Honor.
I'd like to start with the Texas Business and Organizations Code, unless you want to jump in somewhere else. All right. So appellees argue that there's a distinction, this is the first time I've heard this argument specifically, but that there's a distinction between loss of forfeiture and loss of privileges, but that is not what the definition says in the statute in the Texas Business and Organizations Code. In section 11.001, 4, a terminated entity under the Business and Organizations Code means a domestic entity the existence of which has been terminated in a manner authorized or required by this code unless reinstated by this code, or forfeited pursuant to the tax code unless the forfeiture has been set aside. There's no distinction between the different levels of decay in the Texas Business and Organizations Code. And I would urge this court to look at all of the opinions cited in Appellee's briefing carefully and look at what the holding was. If the survival statute wasn't raised and it wasn't before the court and it wasn't addressed, it's not part of the court's holding. Here, the legislature was clear, and this definition in section 11.001 was in effect during this case. The first revision, like I said, was in 1993. That's when the legislature first took to, revise the statute to make sure that it was clear that a forfeiture under the tax code would also be included in the business code. It's been carried forth since 1993 in the definition of this section. When section 11.356 says under this chapter, it includes the definitions at the beginning of the chapter, which is 11.001. So that right of survival applies. The case that I cited earlier is a good case to look at. There's also another case from the 14th Court of Appeals recently from 2023 that this court can look at on the same interplay between the statutes. It's Taylor versus Hunt Andrews Kurth, 2023 Westlaw 4502147. In cases where it has been alleged that there is a right of survival when there's a forfeiture under the tax code, Texas courts have held that that right of survival continues. Next, I'd like to talk about the individual claims. Appellees argue that, so I'd like to clarify, under their statute of limitations ground B at Clerk's Record 353, first they talk about statute of limitations as to, they're talking about Bay Area, the individual plaintiffs filed before the statute of limitations. Then their ground 4 is the only ground that addresses the individual plaintiff's claims. The ground is the James plaintiffs have no contract with CW and as individuals lack standing to sue on behalf of Bay Area. And the ground, there's paragraph 14 there, they say all the claims in the case belong to Bay Area, so they should all be dismissed, it's conclusory. Then they talk about contracts, they cite the Nassaular case that's been explicitly overruled, but they continue talking about contracts and standing. And then finally, this is the only point where that ground discusses the individual plaintiffs. They don't mention it again. It says, thus, the James plaintiffs have no standing to sue CW under the contract with Bay Area, comma, and their contract claim must be dismissed, comma, together with the rest of their claims. That third sentence there is the only ground on the extra contractual claims brought by the individual appellants. We discussed, on appeal, we talk about how it's insufficient and just for this court's edification what those individual claims are, but that is that's not a sufficient ground for us to have to respond to in the trial court and explain those individual.
Ms. Schumacher, before you run out of time, can you respond, if we're looking at the exemption again under the DTPA, do we have to look at the $800,000 loan?
It's a separate transaction. Separate parties, well, it's a separate transaction. The liability is through
statute says separate transactions related to the same project though.
It does. So, the $800,000 was part of the closure, was part of the closing of the deal. We do have the listing agreement. It's its own separate contract. So some of the claims would just involve the separate contract, but we've got deception under the DTPA. And our argument was just that the only consideration that we paid, that the loan was not part of the consideration. What we paid was $500,000 or less. There are cases that say that all of the damages, and we would say that the loan maybe wasn't the consideration for the action, but related to damages as it got, there was deception related to the loan as well. But our argument, our non-frivolous, legally cognizable argument is that the consideration was just the commission that we paid for the listing agreement. At trial, when this was being discussed in front of the trial judge, and remember, we have to think about this from the trial judge's perspective and what evidence was in front of the judge, and we have to give that judge deference, right? It's abuse of discretion, but also we're looking for any legally sufficient evidence on any kind of finding or conclusion that this court could imply that could support the trial court's judgment. And she heard the parties in front of her admit that within the case law there was a gray area, that the cases were not clear, that they could be read multiple ways. There wasn't a lot of discussion previously about the loan specifically. It was a legally cognizable argument that the consideration was just the commission that was paid. It was not frivolous. And this court doesn't need to determine whether the large transactions cap applies. Even losing arguments are not frivolous. This court just needs to determine whether there was any legally cognizable basis for us to bring this claim on behalf of consumers under the DTPA. And in looking at the evidence and whether it was legally sufficient, the court has to consider, because no findings or conclusions were requested, anything upon which the trial court could have exercised its discretion. It's about the highest standard of review.
Any further questions? Thank you both for your argument and your briefing. We really appreciate it. This case is now submitted and we are now adjourned.
Rise.